Hey everyone, it's Rob Ryder. It's April 9th, 2013, and I'm going to try to explain what is really a very simple concept, just too simple to understand, apparently. And so, if you're of the mind that you need to go into court and battle these people to the end and, be the private attorney general sitting in the courtroom, well, then this isn't for you. And, I'm not going to debate with people that believe that. If that's what they want to do, fine. I think there's a much easier way to do it. I'm going to show you the law or the written word that shows that it is correct, and every man can decide to do what they want to do. But if you're looking to have it simple, not go into their court, have your property returned to you, well, we're trying a little bit different way than most. I have no interest in a dismissal. As far as I'm concerned, they committed a crime. Right? They brought a false accusation against you. That's a crime. Needs to be prosecuted as a crime. If it's not prosecuted as a crime and you know about it, well, you're guilty of misprision of felony. Go figure. So this is about the public's prosecutor. In other words, prosecutes crimes for the public, for you, versus the public prosecutor who prosecutes the public, you, for the state. All right, you got a public's prosecutor and a public prosecutor. Public's prosecutes for you because you're one of the public, and the public prosecutor prosecutes the public for the state. Go figure. That's the way I read it. So, let's see what we got here. What are we going to look at? Let's look at some stuff here. It's on a Black's Dictionary, a private prosecutor. One who sets in motion the machinery of criminal justice against a person whom he suspects or believes to be guilty of a crime by laying an accusation before the proper authorities and who is not himself an officer of the government. You are a private prosecutor. If you lay before the proper authorities an accusation, a complaint, an information, call it what you will, do it and put it under oath, and it just became a living being in chancery. You must put your complaint under oath. The reason is because they never do, and they never can, and it's just that frickin' simple. So the private prosecutor is the one who sets the motion. Well, how do you do that, man? If any of you ever watched Return from the Wizard of Oz, what did TikTok say? Right? Keep his action charged. You need to bring it to him. One who sets in motion. We just heard those words last week in a courtroom with Rich. The judge was asking Rich to motion him into the equity side, which is really what criminal justice is. Criminal justice is pointing out crimes. Crimes are sins. Sins are a matter of faith. Faith is determined by the Court of Chancery. The Court of Chancery is under the jurisdiction of the Vatican. To defy the Court of Chancery will bring the thunderous wrath of the Vatican upon you. So said a chancellor of a Court of Chancery in Tennessee. I'm not going to disagree with him. I want to figure out how to use that. Okay, what's Bouvier say a prosecutor is? He who prosecutes another for a crime in the name of the government. That's one. Prosecutors are public or private. The public prosecutor is an officer appointed by the government to prosecute all offenses. He is the attorney general of or his deputy. A private prosecutor is one who prefers an accusation against a party from party whom I guess he suspects to be guilty. Every man may become a prosecutor, but no man is bound except in some few of the more enormous offenses, as treason, to be one. But if the prosecutor should compound the felony, he will be guilty of a crime. So, every man can be. Apparently no man has to. Just depends on how enormous the crime is. Right? You don't need to bring everything to the court's attention. But as treason, right? Except for a few of the... So treason you need to bring to somebody's attention. Well, there's a thing called misprision of treason. And that's when an officer, duty bound, doesn't do their duty. That's treason. And they're all in the military. They're just, what did the judge say in Rich's case? I'm just a public servant. Well, I'm going to make your ass the public's prosecutor. And what's it mean to compound a felony? Criminal offense consisting of the acceptance of a reward or other consideration in exchange for an agreement not to prosecute or reveal a felony committed by another. But the prosecutor should compound a felony. He will be guilty of a crime. So if you accept a reward or other consideration in exchange for an agreement not to prosecute or reveal a felony committed by another, you have to point out the crime. You can't win in civil court. Civil court isn't a criminal court. And if you don't point the crime out for what they're guilty of, for taking your property, well, then you're not going to get a frickin' remedy. Eventually it has to become a criminal case, and all that means is it's going to the court of chancery. In equity. Because equity will not allow a statute to be used as an instrument of fraud. The prosecutor has an inducement to prosecute because he cannot, in many cases, have any civil remedy until he has done his duty to society by an endeavor to bring the offender to justice. We have to point out the transgressions. What would Jesus do? He'd point out a heretic and tell him. Pharisee, tell them they're wrong. If a prosecutor acts from proper motives, he will not be responsible to the party in any damages, though he was mistaken in his suspicions. But if, for a motive of revenge, he institutes a criminal prosecution without any reasonable foundation, he may be punished for being molested in damages and in action for a malicious prosecution. Yeah. All right, so you better have some evidence to substantiate your claim. Wikipedia, a private prosecution is a criminal proceeding initiated by an individual or private organization, such as a prosecution association, such as the district attorneys, instead of by a public prosecutor who represents the state. And who's the public prosecutor? Private prosecutions are allowed under common law but have become rare in modern times as most prosecutions are now handled by professional public prosecutors instead of private individuals. Or they'd like you to think so. But they're really private prosecution associations prosecuting you as somebody's attorney. Canada is a federation, and therefore, see, none of these are ever, nothing they bring against us is ever a criminal proceeding because they never put their complaint under oath. The best they can have is a complainant witness, and a complainant witness is not a complainant. Therefore, if there is no complainant, yet there's a complainant witness, well then, he just brought a false accusation. He committed perjury. There's no complainant. Canada is a federation, and therefore has both federal and provincial offenses which can be privately prosecuted. Federally, they are criminal and statutory offenses. Provincially are provisional and municipal ordinances. Criminal offense procedure for private charges. This is what happened with Dean Clifford, as far as I'm concerned, because his guys took something to the Justice of the Peace. Very basically, a citizen organization approaches a Justice of the Peace to present evidence of each element of an alleged offense. And so, there were certain things that were sent, that were tried to get Dean out of jail. And one of them was to put a complaint under oath and take it to a Justice of the Peace. As far as I know, that was like the last thing tried before he got out. And now, I think they're calling it a habeas corpus, but I don't know that it was written like that. And again, it really isn't what the title is. It's what the damn paper says. And the paper was pointing out that there was no criminal complaint filed against Dean. The same thing with what happened with Rich. There was no criminal complaint filed against Rich. There was something in by a complainant witness, but there was no complainant. And when you point this out to the proper authorities, under oath, it has to be investigated. So the justice then sets up a hearing with a judge to determine whether there is evidence on each element of the offense. And if approved, the Crown does not intervene and terminate the charge. Called staying the charge. then it's allowed to proceed to and through court via criminal procedure. And if approved, and if the Crown does not intervene and terminate the charge, called staying, they didn't stay the charge, they stayed the proceeding. And the reason they stayed the proceeding, just go look at the frickin' definition, it's because there was a procedural error made. Well, what was the procedural error? There was no complaint under oath from a complainant. Provisional offenses procedure for private prosecution. Each province in Canada dealt with private prosecution of provisional offenses in their own way. Below is a list of various provinces and how private prosecutions dealt with in each of them. In Ontario, the procedure for commencing a private prosecution provisional offense is governed by Part 3 of the Provincial Offence Act, Section 23, of which provides that any person who, on reasonable and probable grounds, believes that one or more persons have committed an offense may lay an information in the prescribed form and under oath before a justice, parentheses, of the peace, alleging the offense, and the justice shall receive the information. He has no choice. You put it under oath, he's got to take it. The laying of the information as prescribed in Part 3 of the Act allows anyone to commence a prosecution for a provincial offense, whereas Parts 1 and 2 are Act only for provincial offenses officer. And what's that Act look like? Well, here it is, bigger than Stuttgart. This is the provisional Act they're talking about, commencements of proceedings by information. 23. Any person who on reasonable and probable grounds believes that one or more persons have committed an offense may lay an information in the prescribed form and under oath before a justice alleging the offense, and the justice shall receive the information. So some justice received the information that Dean's friends gave to the justice, and then it went to a judge to see if there was probable cause, and the next thing you know, that afternoon, Dean's walking out of jail. Last week, Rich was told, "You're free to go." It's real simple, people. A criminal complaint, bill of complaint, an information, a petition, whatever you need to call it, get beyond the fucking word. It's basically you laying out what they did and putting your name to it under oath. In a colonial America, because the Dutch practice and the expansion of the Office of Attorney General, public officials came to dominate the prosecution of crimes. However, privately funded prosecutors constituted a significant element of the state criminal justice system throughout the 19th century. How about throughout the 20th and into the 21st? The use of private prosecution was incorporated into common law of Virginia and is still permitted there. Private prosecutors were also used in North Carolina as late as 1975 and probably still as of today, since they're all corporations. In the early days of the Republic, prosecutor was simply anyone who voluntarily went before a grand jury with a complaint. Now, we don't go before the grand jury anymore, and there's reasons for it. We'll see soon, because we don't have true grand juries anymore. But by 1871, the principle found voice only in dissent. It is a right, an inestimable right, that invoking the penalties of the law upon those who criminally or feloniously attack our persons or our property. Civil society has deprived us of the natural right of avenging ourselves, but it has preserved to us the more jealously the right of bringing the offender to justice. By the common law of England, an injured party was the actual prosecutor of criminal offenses, although the proceedings was in the king's name. But in felonies which involve forfeiture of the crown of the criminal's property, in other words, your ass is going to jail, it was also the duty of the crown's officers to superintend the prosecution. We're going to give this to a crown officer. What's a crown officer? A justice of the peace. What does that mean? Well, he's the keeper of the king's peace. What king? Depends on your religion. Mine's the King of Christ. It's his law. He came to perfect the law. They're the justices of the peace, the king's peace. The king of the world, the king of the earth. Right? So you got to get it to a justice. There's one court of justice. That's all there is. Anybody who's got a justice in their name is in the one court of justice. And you don't put this into a civil case as a frickin' motion unless you're going to motion the court to move to the criminal side because you're pointing out a crime. Otherwise, you just take your complaint to the justice of the peace directly. Now, does that mean you can mail it to them? Why not? Do I need to use registered mail? Why not? Can I use certified? Why not? Just frickin' do it and find out what happens. You can always try it another way afterwards. Quit trying to think it all the way through to the end. Just go to the next step. Next step is put in a complaint under oath, pointing out the facts, right, and see which way the preponderance of the evidence moves the case. On a criminal complaint, you're just not complaining they broke the law. You also ask for your remedy. Criminal complaint, bill of complaint, petition, information, application. Depends on where you are, what they call it. To deprive a whole class of the community of this right to refuse their evidence and their sworn complaints is to brand them with the badge of slavery. Jeepers. You think we're supposed to be putting in evidence and sworn complaints? What's it say in the Arizona Revised Statutes? Who's a magistrate? Means an officer having power to issue a warrant for the arrest of a person charged with a public offense, and includes the Chief Justice and Justice of the Supreme Court, judges of the Superior Court, justices of the peace, police magistrates in cities and towns. They're all magistrates. They all have judicial power. They're all justices of the peace. Some just have more experience than others. Just like with Moses, went to the guy at the bottom. If it was too big for him, it got passed up. But it didn't come back to you. It went up the line. A complaint may be laid before a magistrate that a person has threatened to commit an offense against a person or property of another. When a complaint is laid before the magistrate, he shall examine on oath the complainant and any witness he produces. Now, what's a witness? Well, a witness can be a document that says, in testimony whereof, like a certificate. It can be foolproof evidence under the seal of a court of record. It can be circumstantial evidence. But a witness can be evidence. It's just how good is your witness? Well, it depends on how many seals you got on it. You got a document under the seal of a court of record that stands in any court in the world, as long as it's lawful. And there is just reason to believe that the commission of the offense threatened by the person complained of is imminent. The magistrate shall issue a summons, warrant, arrest, reciting the substance, yada, yada, yada. You take it to a magistrate. Why is this stuff important? Well, let's look at the Michigan Vehicle Code. I'm sure every state has this, so you're really going to want to go find it, right? Admission or denial, sworn complaint, warrant for arrest. If an officer issues a citation for civil infraction, or if a citation is issued for parking or standing violation, the court may accept an admission with explanation or an admission of or denial of responsibility upon the citation without the necessity of a sworn complaint. If the person denies responsibility for the civil infraction, so if you deny it, right, you write on the thing issued under, the court may accept an admission with explanation or an admission or denial of responsibility is issued for the civil infraction. Further proceedings shall not be had until sworn complaint is filed with the court. So now the cop needs to put in a sworn complaint. A warrant for arrest under 321A for failure to appear on a civil infraction citation shall not issue until sworn complaint relative to the civil infraction is filed with the court. So again, all a traffic ticket is, when you look at it, it's a promise to appear. Now, if you sign that as a promise to appear and don't show up, then the clerk of the court is going to look at your promise to appear and say, well, you promised to appear and didn't show up. You're in contempt of court. I'm going to file a criminal complaint. And he will put it under oath. And they will issue a warrant, and they'll come and get you because you failed to appear. And then they'll go back to, what you were there for in the first place. But they're going to go arrest you because you failed to appear. You promised to appear. Where this is saying if you deny the allegation until the cop puts in a sworn complaint, they can't issue the warrant. And here's the kicker. A police officer knowingly making a material false statement in citation as perjury. A police officer who, knowing the statement is false, makes a material false statement in a citation is guilty of perjury, a felony punishable by imprisonment for not more than 15 years, and in addition is in contempt of court. What's a false statement? A statement that you won't put under oath. A false statement is done by a false accuser, by Satan. If you won't put it under oath, that's a felony. 15 years. So you get a traffic ticket, right? You could, you might want to point this out to them. You put these two sections here on a complaint, sign your name to it, swear to it, and say that you believe that they're violating these statutes because there is no sworn complaint been filed. And give it to a magistrate and make it a criminal case. And who's going to be who's the plaintiff? Or who's the defendant? Well, not the cop. Whoever the cop works for, right? Who's the name of the top of the ticket? Are they coming after you in the name of the state of Michigan, in the name of a city, police department, whatever it is? That's who the plaintiff is. The best the cop can ever be is a complainant witness. And if he's a complainant witness, and there is no complaint, then he's a false accuser because nobody ever put in a complaint. And it isn't that we don't know this stuff. This is just common sense. It's just, what do you do with it? You put a complaint under oath and you take it to the public's prosecutor. Some stuff from Fred Pollock. On the whole, the practical result was that the pursuit of serious crime was taken away from the old local courts and came under control of the king's judges and officers. The precise manner in which this was brought about is under a cloud which envelopes most of the details both of the Anglo-Saxon institutions and of their transition to Anglo-Norman forms. But it's certain that early in the 12th century, the compiler, the so-called Laws of Henry I, represented the old system of blood feud, tempered by acceptance of weregild, which is, paying you because they killed somebody. How much is your family member worth? They had a price for them. And you could pay the blood money. And a very moderate amount of royal interference as still in force. While in the last quarter of the same century, this is the 12th century now, at latest we find that the greater crimes have acquired the Norman name of felony. The prosecution of them is conducted under the name of appeal. Right? So they have us thinking appeal means, okay, this court gave me this answer and I want to go appeal their decision to somebody else. No, an appeal is a prosecution by the person who, under the older law, might have taken up the feud, but the procedure is under the king's authority as soon as it is started and cannot be dropped without leave. The mode of trial, where the fact is denied, is by the Anglo-Norman judicial combat, or in the early part of the 13th century onwards, a verdict of a jury at the option of the accused. And the conclusion, if the accused be proved a felon by failing in the battle or by verdict, is the sentence and execution of public justice. Verdict by a jury. Forget the battle, and we don't have champions going out and so forth. Because that's what they did back then. If two guys had a feud, they didn't fight it. They sent out their one of their knights to fight it for them. As to the name of the proceeding, appeal originally meant accusation. In its application to disputing the judgment of a court, it meant not seeking the judgment of a higher court, and it has come to do in modern times, but charging the judges personally with giving willfully false judgment, or the witness with perjury. That's what your appeal is. That's what you send to the appeals court. You send them a complaint under oath for a willfully false judgment because the court case didn't have any seals on it, because a verified complaint had not been filed properly, and the witness with perjury. Right? And you send it to a justice, to the appeals court, which is all justices. But you don't, ask them to overturn anything. You just say, hey, the judge made a willfully false judgment. Here's the facts. Therefore, the witness committed perjury. Right? And I believe this to be true, and I'll swear my name to it. And you send it to him. What else we got? The power vested in one court to reverse or vary the judgment of another was not within the conception of early English or Frankish law. Right? It's not part of common law. It's a fiction that was developed afterwards. It's not in the common law. It's a creation by statute. Yeah, you got to be careful what we call common law, because lowercase common law is the unwritten law of reason. And then proper case common law is customs and statutes. So English common law is the customs and statutes of England. Well, who writes the statutes? The lords. Right? And they're not writing them for your favor. In fact, they're writing them so they can commit fraud. Well, what are you going to do about that when somebody commits fraud against you? Because the law doesn't care how somebody got a title or title deed. Right? It only cares who has the legal title. You or you. Whoever has legal title is the owner. Really that simple. And right now you don't have the legal title to anything, because none of the contracts for buying a house or anything else have ever been completed. You don't have a frickin' certificate of occupancy for your house. That's one of the requirements to have before the transaction is completed, to have a certificate of occupancy. And in Arizona, to get that, the escrow agent has to pay a $10 lien off for marketing. If they don't do that, then the certificate of occupancy can't be given to you. And Bobby in Arizona went down to try to get one. We don't do that. We give out these, whatever this was. Right? So that's in his complaint. Okay. What else was there? Alright, so this is where all this comes from. Or not all of it, but I'm just trying to show you different sources of what's said, and why not try it? However, okay, the origins of public prosecution at common law. However fundamental he may appear to us, the public prosecutor was a historical latecomer. Judge and jury we can trace back to the high Middle Ages, but the prosecutor became a regular figure in Anglo-American criminal procedure only in the Tudor times. Further, his appearance then was not been noticed in our historical literature, an especially remarkable omission when we discover that the prosecutorial office has originally lodged in the much studied institution, the English magistracy. Magistrates were made the public prosecutor. Ever since Martland coined his famous phrase that under the Tudors and Stuarts the justices of the peace became the rulers of the county, the justices of the peace became the rulers of the county, they have attracted a substantial scholarship. Nevertheless, this major aspect of the work of the magistracy has remained unknown. The present article documents and accounts for the development by which the justices of the peace became the ordinary public prosecutors in case of serious crime, because the justices of the peace became the rulers of the county. Origins of Public Prosecution at Common Law. Just Google it. You'll find this by John H. Langbein. I think you should have a copy and show somebody. I think you should go show the Justice of the Peace if he doesn't know what his job title is. The public prosecutor in Anglo-American criminal procedure performs two primary functions. One is investigatorial, evidence gathering, and this has no firm border with the higher levels of the policing function. The other is the forensic prosecutorial role, representing the evidence to the trier. In other words, he takes it to a judge, just like we saw before, talking about what happened in Dean's case and just earlier in the video, where complaint was given to a justice took it to the trier of the fact, a judge who made a determination. If the prosecutorial officer to which the justice of the peace acceded was a creation of the 16th century, crime itself was no novelty those times. Okay. The justice of the peace takes it to the trier of the fact. Beautiful. Justice of the peace is going to take your complaint to the trier of the fact. He's there for you. That's why Dean's friend didn't need to be there. The justice of the peace was the prosecutor. He was prosecuting it. He was there. He was at the hearing. How then had the English managed throughout the Middle Ages to dispense with the figure of the public prosecutor? So what did they do before? The public prosecutor appeared as a consequence of the fundamental change of the structure of a jury trial. Oh, they changed the structure of a jury trial, which took place in medieval times. The Angevin system of self-informing juries had required no outside officer to investigate crime or to inform jurors of the evidence. Basically, the jurors were the police, right? They go out, find something wrong, come back. Here's the evidence. Boom. If it looked like there was, right, they would be informed and they would issue an indictment. Jurors were men chosen as likely to be already informed. The vicinage requirements, the rule that jurors be drawn from neighborhood where the crime had been committed, was meant to produce jurors who might be witnesses as well as triers. Right? The idea was to have witnesses as well as the triers and the jury. Denunciation to the jury of accusation and proof of guilt to the jury of trial operated informally. Right, so first you have one jury to see if you're accused, then you go to another jury for a trial. Two different juries. So right now they send it to a grand jury, and then you're supposed to have another trial for a trial jury. And the grand jury is looking at the indictment. But what they do now is they don't put anything under oath. It is all simulation of a legal process. And so that's what we're making a complaint about if you're in a court case. In the 13th century, it is the duty of the jurors, as soon as they have been summoned, to make inquiries about facts of which they will have to speak when they come before the court. So the court's the judge, and since the jury isn't there anymore, then the jury/prosecutor is going to investigate the facts. What facts? Well, the ones I gave them under oath to say, hey, it looks like they're doing this. I think somebody's breaking the law. Here's the facts. The system of self-informing juries was breaking down in the Middle Ages. The transformation of an active medieval juries to passive courtroom triers is among the greatest mysteries of English legal history. Like somebody did it on purpose. Still no better understood than when Thayer wrote, as late as Fortescue, it was being boasted that the English jury merged witness and triers, right? They were the witnesses and the triers. On the other hand, Thayer noticed that separation of witnesses and jurors could be found even in the early 13th century in cases disputing the genuineness of deeds. And similar distinction seems to have taken in some felony trials in the 14th and 15th centuries. So we used to have active juries and they became passive courtroom triers. They didn't investigate anymore. That's what we have now. So how do you get around that? I become expected that jurors would be ignorant of crimes they denounced and determined. We cannot seriously hope to identify the cause of the phenomenon whose internal development and timing we still little understand. Yet this much can be said with confidence. The medieval system of self-informing juries could not have survived to modern times. It presupposed a static populace in forms of communal social organization which were dissolving. Yeah, they were breaking up the family groups, scattering us to the wind. Be that as it may, what matters for present purpose is not the cause, but the consequence. The juries were ceasing to be self-informing. If the jury system were not to perish in England as it already had in the continent, some other agency would have to come forward to assume the lapsed function. As the jurors became bare lay judges, it became essential that outsiders undertake for the jurors the job we now call prosecutors. Somebody had to prosecute it. Used to be the jury did it. They investigated. who's going to investigate now? What are the origins of the office of public prosecutor at common law? That question has not been much asked. Lawyers have generally assumed that modern system of lawyer prosecution goes back to the start of antiquity. In the American system, the state chief's lawyer in the jurisdiction, the Attorney General, is nominally responsible for prosecuting crime, aided, however, by many district attorneys and their hirelings. To summarize this, such an arrangement extended back to at least the Renaissance, and indeed in the occasionally infamous cases reported in the state trial series, law officers of the Crown did regularly prosecute. It should suffice to mention only the most celebrated, the shameful, unworthy, never to be forgotten prosecution of Sir Walter Raleigh by Attorney General Sir Edward Coke. Raleigh's case, another state trial, because the Attorney General prosecutes for the state, and Coke, one of the best learned men in the law of all times, apparently, was the Attorney General at the time, had no evidence basically at all, and still got a conviction against Sir Walter Raleigh because he knew how the courts worked. It can, however, be misleading. Precedents when conception understand the criminal procedure which ordinarily used in cases of serious crime. The state trials were extraordinary cases touching on the interests of the political authorities. They were in several respects the subject of special procedure not followed in cases of ordinary felony. To be sure, the procedures were not wholly dissimilar. Legislation established in the middle of the 14th century the principle that capital cases were outside the trial jurisdiction of the council. Only courts constituted by common law writ could deliver accused traitors and felons. It followed that no man need stand trial for his life unless he had first been indicted by a jury of accusation. His right to a jury trial of guilt or innocence was likewise assured, but within common law criminal procedure, there were often significant differences between state trials and ordinary criminal cases. For the state trials, the judges were hand-picked. They sat under special commissions of Oyer and Terminer in London under the eyes of the political authorities. That sounds like the Michigan State Supreme Court. By contrast, ordinary felony was tried locally, usually by royal judges on their regular assize circuits. That sounds like the appeals court judges. In most state trials, the juries were handpicked for a particular case, and they heard only that case. In ordinary cases, the jurors were assembled by the sheriff for both criminal and civil work of the assize. Once impaneled, a criminal trial jury could hear the evidence in 6 or 7 unrelated cases before retiring to formulate verdicts in all. They go through 6, 7, 8 cases at a time in a truly ordinary criminal procedure. Most important of the procedural differences was that the lawyers were typically not involved in the prosecution and defense in cases of ordinary felony. In ordinary felony, where you're the prosecutor, lawyers are typically not involved in the prosecution or defense in cases of ordinary felony. Okay? Well, a justice of the peace, although he may be an attorney, apparently isn't an attorney. He's taken an oath to be a justice of the peace. It's probably a constitutional oath. I bet you it's probably the only one that's taken, because they're the ones that rule the county. It is well known that the accused was regularly denied defense counsel on all trials of the period, political or not. Well, excellent. We don't want them to have defense counsel. We want them to come and answer for themselves. What has not been recognized is that there was usually no prosecuting counsel either. Here the state trials have misled us. We see Lord Coke prosecuting in Raleigh's case, and we assume that some lesser light that the bar must have been doing the same job out of the countryside in less spectacular cases. That assumption is in fact wrong. In few contemporary sources which do purport to describe ordinary criminal trials, for example, Sir Thomas Smith's accounts, there is no prosecuting counsel. We have not marked this point in our historical literature. The oversight is certainly understandable. Lawyers inclined to project modern practice backwards unless there is clear contradiction, in part because there are no law reports from ordinary criminal accounts process in these years have seldom realized how exceptional the state trials were. Actually, the absence of law reports from criminal process, when they do not exist for contemporary civil litigation, is itself telling. Law reports are lawyers' literature. They do not develop where lawyers have no role. Go figure. Law reports are where lawyers have a part. If they don't have a part, there's no law report. Once we are alert to the absence of the lawyer prosecutor, we have little difficulty explaining it. The principal job of modern prosecuting counsel is to manipulate the rules of evidence at trial, and those rules were non-existent through the 16th and most of the 17th century. That's what the principal job of a modern public prosecuting counsel is, to manipulate the rules of evidence. The law of evidence is the law of jury control. It regulates what the jury can be told at the trial. But that presupposes the modern format of a jury trial, which is only just coming into currency in the 16th century. A courtroom instructional proceeding held for the benefit of a passive and ignorant panel of lay judges. The other important responsibility of prosecuting counsel in modern law is the operation of complex pre-trial and trial procedural rules. Complex pre-trial and trial procedural rules. This is why you don't want to play their game. The making of timely motions to suppress and the like. These rules, too, are comparatively recent. Criminal trial was still a fluid form in Sir Thomas Smith's day. He depicted a running altercation between the accused and the accusers, and in this respect the state trials are quite in accord. Moreover, many of the modern procedural intricacies have derivative of the law of evidence. Finally, because the possibilities of appellate review were extremely restricted, there was no effective mode of enforcing procedural rights. Right, so, anyways, the whole thing is set up against you. The writ of error lay only for technical defects of the record, and two practices of the time made it all but certain such defects would not be recognized. One was a rule forbidding defense counsel in most cases. The other was the practice of withholding from the accused any copy of the indictment, the significant item of the record. Right? You never see the indictment. The juries were becoming passive. It was becoming essential that outsiders come forward to inform them. The responsibility was not being delegated to lawyer prosecutors apart from the rare state trials. What was to be done? For a very long time, really through the 19th century, the English relied on a predominant, although not exclusive, component of private prosecution. The aggrieved citizen could inform the juries in a court, as in medieval times, as he had informed them out of court. So this is when people try to go to, what they think is the grand jury. They don't exist. We know that the citizen volunteer was expected in the 19th or 16th century criminal trial. The proclamation of the crier after impaneling the trial jury was more than ceremony. If any can give evidence or can say anything against the prisoner, let him come now, for he standeth upon his deliverance. The assize judge who was conducting the trial exercised general superintendence over those who responded to the call, but witness and prosecutor were one. The citizen prosecutor was neither a lawyer nor an officer of the state. In modern American practice, where the public prosecutors developed a monopoly over investigation and conduct of criminal litigation, this citizen figure lives on as the complaining witness. But he's just a witness. There is no complainant. The obvious drawback to any system of gratuitous citizen prosecution is it is unreliable. There will be cases where there are no aggrieved citizens who survive to prosecute, and others where the aggrieved citizens will decline to prosecute or be kept inept at it. In other words, you'll be bought off. Because the public interest in law enforcement cannot allow such gaps, the English had to admit an official element in their system of citizen prosecution. The major steps were directed and taken under Mary into statutes which almost imperceptibly raised the justice of the peace as the public prosecutors of felony in England. the justices of the peace as the public prosecutors for felony in England. By way of background to these statutes, it's useful to recall the few generalities about the JP. They were in truth the Tudor men of all work. They were the most part leading local gentry, appointed by royal commission for each county and certain cities. The JP originated in the 14th century as law enforcers, keepers of the peace. Foremost among those duties was the arrest of vagabonds and rioters. By mid-century, the keepers were justices sitting collectively in their quarterly session. They comprised law court for criminal matters. In the 15th century, the JP's criminal jurisdiction was extensive. Felonies were routinely indicted, convicted, executed in the sessions of the peace. By the 16th century, it was rare for JPs to try felons. The assize system had been revitalized, and now the King's Court took over, and felony cases were generally held for trial before the royal judges on a periodic circuit. But the JPs continued to exercise their trial jurisdiction over lesser crime, the standard misdemeanors and growing body of regulatory offenses, right? This is like the district court in Michigan. That's what they have jurisdiction over. Misdemeanors and anything larger than that goes to the circuit court. They had also become licensing and administrative body, and the line between the law court and regulatory authority was, to some extent still is, shadowy. Yeah, right? They're administering the bankruptcy and they're also enforcing the law. Part of the reason the JPs drifted into what we think of as administrative business is that so much of it has been conducted in forms of criminal litigation, with presenting an indicting juries being used to take orders in matters such as road repair and damage. Yeah, those are the liens they put against you. So when they say you haven't exhausted your administrative remedies, right? You haven't gone to the justice of the peace to have him administer the law. You need to put in a criminal complaint, a complaint under oath, to a justice of the peace. Okay. Anyways, this goes on and on and on, and read it to your pleasure. But these are the reasons I think that we go to a justice of the peace. It doesn't need him any harder than that. Just real quick, I don't know how much more time I got. Again, this is the complaint we put into Rich's case. All right, and so somebody's a complainant. The state of Michigan is the respondent. Why? Because we're complaining about a case from the past which somebody's still being held to today. And who is the plaintiff on that case? The state of Michigan. Well, of course, the state of Michigan doesn't exist, but it has officers, agents, principals. They're responsible for it. So the complainant believes respondent, through its principals, officers, and agents, violated Michigan Penal Code, hereinafter called the Penal Code, as well as Constitution of Michigan, the Michigan Court rules, simulating legal process as part of a conspiracy to enforce legal contracts by usurping the authority of public offices and abusing the office's police powers. We know they're acting. Right, it's all color of law and it's all simulation. So frickin' point it out, it's a crime. Penal Code, legal process, impersonation. A person shall not impersonate, falsely represent himself or herself as, or falsely act as a public officer or a public employee. In other words, have they taken the proper oath? By what authority do they bring this charge? Serve, execute, otherwise act to further the operation of any legal process or unauthorized process. Well, what's an unauthorized process? Well, that would be one that simulates a legal process. It's a complainant's belief that the actors posing as public officers have not signed, sworn, filed for record the oath of public office mandated in the Constitution of Michigan, 1963. And it very clearly says this is the only oath that they can take. I do solemnly swear that I will support the Constitution of the United States. Which I believe when they say Constitution of the United States, which one are they talking about? Well, I guess, okay, Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of office of whatever according to the best of my ability. If they didn't take that oath, right, they can't hold a state office. All officers, legislative, executive, judicial. So they're guilty of simulating a legal process. A person or agent of a person shall not, by personal service, mail or otherwise, serve or cause to be served upon a debtor a notice or demand of payment of money on behalf of a creditor that is not authorized by statute or court of this state and that simulates in form, substance, legal process issued out of a court of the state. So one of the things is that in Michigan, the summons shall say on it, in the name of the people of the state of Michigan. But when people get that kind of summons, it don't say that. Complainant was subjected to a simulated legal process as the defendant in the following fictitious criminal case. Whatever it was, whatever caused it. It is the complainant's belief that no complaint was signed and sworn to before a judicial officer or court clerk violating Michigan Court Rule 6.101, which says they have to do it. A complaint must be signed and sworn before a judicial officer or court clerk. There's no way around it. Violation by the respondent and the conspiratorial actions of its principals, officers, and agents resulted in unlawful imprisonment, forfeiture of property of the complainant, and continued violation of complainant's civil rights to enforce an illegal contract by agents of the respondent with no lawful authority. Respondent is an enemy of the state. I say they're guilty of treason. Conspiracy to commit an offense or legal act in a legal manner. Any person who conspires together with one or more persons to commit an offense prohibited by law or to commit a legal act in an illegal manner is guilty of the crime of conspiracy, punishable as provided therein. Going to commit a legal act in a legal manner. It's certainly lawful to arrest somebody as long as it's done lawfully. Certain illegal contracts. Certain contracts illegal where made. Every contract, agreement, understanding, in combination declared void and illegal by the first section of this chapter shall be equally void and illegal within the state, whether made or entered into with or without the state. Declared void and illegal. On March 21st, two agents of the respondent continued the respondent's habitual criminal activity by kidnapping the complainant and holding for ransom in a private prison. Upon paying the ransom, complainant was provided yet more evidence of a simulated legal process in the form of, and basically what they gave Rich was a complaint that was filed 2 days after he was put in jail. But it didn't have a complainant, it just had a complainant witness. So in other words, there was no complaint when they put him in jail. It's a false arrest, false imprisonment, bing, bing, bing. There is no complaint sworn and signed before a judicial officer for their charge and instrument. And I am being prosecuted by a false accuser, slandering complainant's good name in violation of God's law, and now this court is informed and made aware. They now know what's going on. The actions of the respondents, principals, officers, agents has manifested false accusations upon the complainant and the act of larceny on the part of the respondent. Larceny, property penalties. A person who commits larceny by stealing any of the following property of any person is guilty of a crime as provided in this section. Money, goods, and chattels, bank notes, promissory notes, exchanges, bills of exchange, other bills, book of accounts, a deed or writing containing a conveyance of land, right? You take that stuff, it's larceny. If it's more than $20,000, it's a 10-year prison felony. But we could get them for 18 U.S.C. 1341, fraud and swindles. That's 25 years. Falsely and maliciously accusing another. Falsely and maliciously accusing another is a crime. Any person who shall falsely and maliciously by word, writing, sign, or other accuse, attribute, or impute to another the commission of any crime, felony, or misdemeanor, or any infamous or degrading act, and impute and attribute to any female for want of chastity shall be guilty of a misdemeanor. Right? Basically, that's slander. If they will not put their complaint under oath before a justice of the peace, just like we have to, they're guilty of slander. They're a false accuser. Right? Satan's entered their body, and we got to scare Satan out. Complainant asks the court and chancery for permanent injunctive relief, judgment against the respondent, restoring the complainant's good name, damages, and any other remedy or relief this court sees just to order. Whoever, the complainant in the foregoing bill, makes oath that the statements in his foregoing bill made as of his own knowledge are true, and those made as on information and belief he believes to be true. Either they're true or you believe them to be true. Whoever you are, a citizen of the United States of America, it's up to you. But son of God there, whatever you want. Okay, that's about my last attempt trying to explain why we don't want to do a praecipe into a court case and go into the civil case and keep going, because you can't do that. If you don't point the crime out first, you can't get your civil remedy. Very first part of this video. I'm going to leave it at that. See y'all later.